We got great news to share with you. We got 2 green cards approved within 1 year and 2 months. In this video, I am going to talk about the latest great news that we have. My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing every day with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and like, share. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. If you need a consultation with me, please schedule it by using the consultation link in the description box below. Let's get right into the subject. Those are the people who initially came with a visa and later on applied for asylum. Then later on their child turned 21 and the child petitioned for them. But guess what? They made a mistake to transfer the case for consular processing. But remember what? Because the person applied for asylum, because it's like 2 people, right? A husband and wife, they applied for asylum, they couldn't go for consular processing. So, but unfortunately for them, they keep uploading documents because the lawyer they had before keep telling them that you can go for consular processing instead of adjusting status in the US. So they keep doing all the process that you have to do in order to go for consular processing, and they were just waiting for an interview date. But the consulate keeps sending them requests for evidence letters, in notice for intent to deny. But then at some point they really got frustrated. Then they came and contacted me, had their consultation. I went over the case and find out that they can adjust status here because first of all, they initially came with a visa. They have no misrepresentation, none whatsoever. They applied for asylum. Their child turned 21. He's a U.S. citizen. Of course, immediate relative of a U.S. citizen. Then they can adjust status in the U.S. I told them we're gonna cancel this consular processing process and then apply for adjustment of status here in the U.S. That's what we did. We had 2 requests of evidence letters. We had to do it. We had a request for evidence because of public charge. So we had to supplement information because, you know, public charge simply means that you have to show to this government that you cannot become a public charge. You cannot become a burden to the government. Therefore, there are certain requirements that you have to meet, right? Sponsorship requirements that you have to meet. So we had to pretty much show their income as well, because remember they're working with a C8 visa, work permit, and we had another sponsor. So we had to really come up with a strong response to the request for evidence so that they don't deny it. So, and then 1 year and 2 months later, the case is approved. The moral of the story for this case is this. This was a mistake, first of all, to apply when you file the Form I-130. Remember, you have to notify USCIS where you want to do your green card. Are you going to go to the consular processing process, or are you going to adjust status in the US? In order to adjust status, certain requirements have to be met first, right? But those are the things that you consult with a qualified attorney in order to help you out. They did have an attorney, but unfortunately this attorney didn't know the process correctly and mistakenly sent their case to consular processing. Mind you, those people have an asylum pending. If they had gone to consular processing, it was going to be bad for them. Then the asylum in question was going to be deemed frivolous, because you claim persecution, then you go back home, then you're trying to get a visa. That's where they're going to see in the system that you have an asylum claim. Then you say you cannot go home. Now you find yourself home voluntarily So what's going on? It was going to be a lot of questioning, a lot of notice for intent to deny, and probably a denial for misrepresentation. And guess what? If you do not have a parent, a spouse, U.S. citizen, or lawful permanent resident, you cannot waive misrepresentation. So that's why it's important for a person who's trying to adjust status to get their consultation. I always suggest at least two different people, so you can get two different advice, second opinion, and then just go with what you think is a valuable opinion. But in this case, really, they were lucky. Somebody introduced them to me, and we got this thing corrected, and then they get their case approved. Don't be that person. Don't be that person who just goes and file for cancel processing when they can adjust status here. Don't be that person who goes and file for cancel processing when they have an asylum pending and they're trying to go out, really, outside of the country with an asylum pending. This is a big no. It's going to create a lot of misrepresentations, dismissibility issues, and that cannot probably be waived, and potentially a frivolous asylum claim that cannot be waived at all. It's a permanent bar. So that's why you don't want to be that person. That's why you need to schedule your consultation by using the consultation links in the description box below. Until next time, bye-bye.